Hello, and thank you for choosing to view this training on parent rights and special education. This training will go over the parent rights provided by the federal education law, the Individuals with Disabilities Education Act. Learning about this law and knowing your rights is taking one big step to becoming an empowered parent and being the very best advocate possible for your child. My name is Sharon Blackman, and I'm the Director of Training at Families Helping Families of Greater New Orleans. Our center, located in Jefferson Parish, is one of 10 nonprofit family resource centers in the Families Helping Families network of centers all across Louisiana. We're here to provide support to parents of children, youth, and even adults with disabilities or special health care needs. And we do this through individual help, information sharing, outreach, and of course, trainings like this one. Families Helping Families of Greater New Orleans provides over 100 training opportunities every year on special education and disability related topics. So we invite you to check out our calendar of events at fhfofgno.org regularly and register for any upcoming live training webinar that might be of interest to you. As a result of this training, I hope to increase your knowledge of some frequently used special education acronyms, procedural safeguard language from the Individuals with Disabilities Education Act, also known as IDEA, your rights under these procedural safeguards, how procedural safeguards are defined, and then I'll share some website resources. Throughout this presentation, I'll be using acronyms, and I do try to define each of those as I use it, but I want you to get accustomed to the acronyms that are used in education so that you'll feel a little more comfortable going into those IEP meetings or other school meetings where people use acronyms just in their everyday language. So some of the frequently used acronyms you'll hear today are as follows. LEA is the local education agency or school system. BESE is the Board of Elementary and Secondary Education, also known as Louisiana State School Board. IDEA, as I've mentioned, is the Individuals with Disabilities Education Act, and IEP is the Individualized Education Program. You'll also see FAPE, F-A-P-E, which is Free Appropriate Public Education. IEE is the Independent Educational Evaluation. FERPA is the Family Educational Rights and Privacy Act, and ERP is the Early Resolution Process. Now, just to back up and give you a little background, not too much, so don't get excited. President Gerald Ford signed into law the Education for All Handicapped Children Act in November of 1975, but that original law was only for children 3 and up. It was not for infants, and it wasn't until the following year that that birth to third birthday part was added, which is now known as our Part C services or early intervention, and that in Louisiana is called Early Steps. This landmark law's name was changed to the Individuals with Disabilities Education Act, or IDEA, in a 1990 reauthorization. The law was last reauthorized in 2004, and the department has periodically issued new or revised regulations to address the implementation and the interpretation of IDEA, because we all know that those laws can be interpreted in different ways. The Individuals with Disabilities Education Act provides specific rights to students and parents of students qualifying for or suspected of needing special education and related services. And these rights are referred to as procedural safeguards. These safeguards are designed to ensure parental participation in the special education process and to ensure the student's rights to a free, appropriate public education, or FAPE. Procedural safeguards don't spell out what services you're going to receive. They describe the ground rules for how you're going to work with your school. IDEA states that schools are required to provide you, the parents of a child with a disability, with a notice containing a full explanation of the procedural safeguards available under IDEA and the U.S. Department of Education. A copy of your rights have to be provided to you at a minimum of once a year. They're usually given at your IEP meeting or around that time, but there are other times that you should also receive a copy. When your child is initially evaluated, you should have received a copy or you should receive it. When you file a state complaint, when disciplinary action against your child constitutes a change of placement, and then basically anytime you request it. But it is available on the Louisiana Department of Education website at louisianabelieves.com. And I'll have that in your resources later in this presentation. Your rights are also referred to as procedural safeguards. Parents have quite a few rights. Parents have the right to receive a procedural safeguard notice, so you have the right to know about your rights. Parents have the right to participate in the special education process. You can access your child's educational records. You may expect confidentiality of your child's personal information. You have to be provided informed consent before certain things can happen, and we'll go over those shortly. You must receive prior written notice, and we'll also go over that shortly. You'll receive information in a language or way that is understandable to you. You will receive an independent educational evaluation if you disagree with the school's evaluation. You have the stay put right, and you have dispute resolution options, all covered under your procedural safeguards. Now let's jump in. We're going to talk a little bit about each one of these rights. Your right to a procedural safeguard notice. As I said, your school has to provide you with a written explanation of your rights under both IDEA and Louisiana laws. You should receive the procedural safeguards notice every time you have an IEP meeting or an evaluation. And the purpose is simple. It's to inform you completely about your rights that are available under IDEA and Louisiana laws. And of course, this also includes all the protection that your child has as well. Now, in Louisiana, the document looks like the picture on your screen, and it's called Louisiana's Educational Rights of Children with Disabilities, Special Education Processes and Procedural Safeguards. So we don't say that very quickly. I should also mention that this document comes in English as well as 7 other languages, and also that FHF centers are mentioned on page 7 as resources for families of students with disabilities. And as I said, you can download this booklet from the Louisiana Department of Education website, louisianabelieves.com. A link to the Louisiana Department of Education's procedural safeguard notice will be provided to you in the resource section. And so you'll be able to access that once you've downloaded the slide deck. One of IDEA's foundational principles is the right of parents to participate in education decision-making regarding their child with a disability. The law is very specific about what school systems have to do to ensure that parents have the opportunity to participate. Parents have the right to participate in meetings, those related to the evaluation, identification, and educational placement of their child, or those related to the provisions of FAPE, your free appropriate public education. Parents have the right to be team members of any group that decides whether their child is a child with a disability and meets eligibility criteria for special education and related services. Parents have the right to be members of the team that develops, reviews, and revises the IEP for their child. And parents have a right to be members of any group that makes placement decisions for their child. IDEA states that the education of children with disabilities can be made more effective if we strengthen the role and responsibility of parents and ensure that the families of these children have meaningful opportunities to participate in their own education. Parents have the right to see and get an explanation of their child's education records, and you can ask for corrections and additions as well. These rights are protected by IDEA as well as FERPA, the Family Educational Rights and Privacy Act. Under IDEA, the participating school district has to permit you to inspect and review any education records relating to your child that are collected, maintained, or used in any way by your school district. And they have to comply with your request to inspect and review the education records of your child without any unnecessary delay and before any IEP meeting or due process hearing, and never more than 45 calendar days after you've made the request. Your right to inspect and review education records includes your right to a response from the school district regarding your request for the records. It includes your right to request that the school district provide copies of the records if that's the only way you can review them. And it includes your right to have your representative inspect and review the records. Now, a school district may charge a fee for copies of records that are made for you if it does not prevent you from inspecting and reviewing the records, but they cannot charge a fee to search or retrieve the records. Also, each school district has to keep a record of anyone who has accessed your child's records. Parents have the right to expect the school to protect their child's information. Confidentiality of information includes personal information like your child's name, address, social security number, and other personal characteristics or information that it would make it possible to identify your child with reasonable certainty. Your school district has to inform you when any personally identifiable information that was used by the school to educate your child is destroyed. A permanent record of your child's basic information like name, address, phone number, grades, attendance records, the classes they took, and the grade level they completed, the year they completed it, those things can be maintained without time limitation. Just think about that as like a transcript. They will always keep a transcript of your child on file. Informed consent is another of your rights. Before a school district can evaluate your child or before they can provide special education for the first time, the school has to inform you of what's involved. You have to give consent in writing before the school can move forward. Informed consent is one of your rights under the procedural safeguards, and it means that you have been fully informed in your native language or other mode of communication of all information about the action for which you're giving consent. You understand and you agree in writing to that action, and the consent describes that action and lists the records, if any, that will be released and to whom. It should also state that you understand that the consent is voluntary and that you may withdraw your consent at any time. Informed parental consent is required before the school district conducts an initial evaluation or a reevaluation. It's required before they provide any special education services. And it's required before they can invite non-school agencies to participate in IEP meetings to discuss your child's transition to adult life. And that may mean agencies like Louisiana Rehab Services or your local Human Services Authority, agencies that will be involved with your child after high school. The school district has to make reasonable efforts to obtain your informed consent before providing special education and related services for the first time. If you don't respond to a request to provide your consent for your child, or if you refuse to give consent, or if later you revoke it, then they cannot provide special education for the first time because you have not given your consent. And also, they can't use the procedural safeguards like mediation, due process, resolution meeting, or any of those things to obtain permission to provide services without your consent. Your school district is not in violation of providing a free, appropriate public education, and it's not required to have an IEP meeting if you refuse to give consent or you revoke your consent. And this is also true if you don't respond to the school district when they request consent. So be sure you pay attention to everything that comes in from the school. The school must give you prior written notice before it changes your child's special education program. And this includes when the school wants to add services or deny services. If they want to make changes to your child's IEP, then you need to be informed and you need to participate in that decision-making process. The prior written notice provision under IDEA says that the school must give parents written notice anytime it adds, changes, or denies educational services to their child or wants to change the child's placement. Now, the content of the written notice has to do several different things. It has to describe the action that the school district is proposing or refusing. It has to explain why they're proposing or refusing to take this action. It has to describe each evaluation procedure, assessment, screening, or whatever report your school used in deciding to propose or refuse the action. It has to include a statement that you have protections under the procedural safeguards provisions in Part B of IDEA. It has to tell you how you can obtain a description of the procedural safeguards if the action that your school district is proposing or refusing is not an initial referral for evaluation. It has to include resources for you to contact for help in understanding Part B of IDEA. It has to describe any other options that your child's team, IEP team considered and the reasons why those options were rejected. And then lastly, it has to provide a description of other reasons why the school has proposed or refused the action. The prior written notice, that whole written part and the whole process is sometimes overlooked by the school district as well as the parent, but it should be something that everyone wants because it provides written documentation of a request or a denial. It gives you that paper trail. And if the school calls you to inform you of a change, that does not satisfy this requirement of the law. It is law that they give you prior written notice. If your school district offers parents the choice of receiving documents by email, you may choose to receive prior written notice, procedural safeguards notice, and notices related to a due process complaint electronically. You also have the right to get all information from the school regarding the identification or delivery of special education services in an understandable language to you. Whenever the school provides you with written notice, it has to use the language that's understandable to the general public. It must also be in your native language or other mode of communication, including Braille, unless it's just not feasible to do so. And if your native language or other mode of communication is not a written language, then the school has to ensure that the notice is translated to you orally or by other means in your native language or your mode of communication. They must ensure that you understand the content of the notice, and they must be sure that there is written evidence that the requirements have been met. Now, native language, when used regarding an individual with limited English proficiency, means that it's the language that's normally used by that person, or in the case of a child, the language normally used by the child's parents, and also the language used in all direct contact with the child, including the evaluation, the language normally used by the child in their home or their learning environment. Now, for a person who's deaf or blind or a person who has no written language, the mode of communication is what that person normally uses, like sign language, Braille, or verbal communication. You have the right to obtain an independent educational evaluation or an IEE if you disagree with the evaluation of your child that was obtained by your school district. If you request an independent educational evaluation, then the school district has to provide you with information about where you can obtain the IEE and about the school district's criteria that apply to those evaluations. An independent educational evaluation is an evaluation conducted by a qualified examiner who is not employed by the school district that is responsible for your child's education. Public expense means that the school district either pays for the full cost of the evaluation, or they ensure that the evaluation is otherwise provided to you at no cost. And that's consistent with the provisions of IDEA, which allow each state to use whatever public or private resources there are to meet the requirements. You have the right to an IEE of your child at public expense if you disagree with an evaluation of your child obtained by the school district, but there are some conditions. The first condition, if you request an independent evaluation, an independent educational evaluation of your child at public expense, then your school district has to, without delay, either file a due process complaint to request a hearing to show that its evaluation was appropriate, or they have to provide an IEE at public expense. Now, keep in mind, they may later demonstrate in a hearing that the evaluation of your child that you obtained did not meet the school district's criteria. The second condition, if your school district requests a hearing and the final decision is that their evaluation of your child was appropriate, you still have the right to an IEE, but not at public expense. And then the third condition, if you request an IEE of your child, the school district may ask you why you object to the evaluation that they provided, but they cannot require an explanation, and they cannot unreasonably delay either providing the IEE or filing due process complaint to defend their evaluation. Now, keep in mind also, you are entitled to only one IEE of your child at public expense each time your school district conducts an evaluation of your child with which you disagree. So you can't just get IEE after IEE at public expense because of one evaluation that you disagreed with. If you obtain an IEE at public expense, or you share with the school district an IEE that you paid for, then they have to consider the results of the evaluation of your child in any decision made with respect to the provision of FAPE, but only if that IEE meets the school district's criteria. Also, you or your school district may present the evaluation as evidence at a due process hearing regarding your child. If the IEE is at public expense, the criteria under which the evaluation is obtained, including the location of the evaluation, the qualifications of the examiner, for example, must be the same as the criteria that the school district uses when it initiates an evaluation. Unfortunately, sometimes you may disagree with the school district about your child's education, and you just can't come up with a resolution. So the Individuals with Disabilities Education Act provides you additional rights when you need a more formal process to resolve your dispute. You can use these processes to come up with a resolution around your child's disability identification, their evaluation, their eligibility or placement, their services, or the reimbursement of services that you obtained privately. IEP facilitation is one of the dispute resolution options, and it's a non-adversarial dispute resolution method that's offered by the Department of Education. It's free of cost to both the parent and the school. However, both parties have to agree to the process, and if they do, then the state will assign a neutral person called an IEP facilitator to help navigate that process and get that IEP completed. Mediation is another way to resolve differences that's also voluntary, and it requires an agreement by both the parent and the school. And that's where a third party is brought in. I was trying to think of the word, not independent, a neutral, thank you, neutral third party is brought in to mediate conversations and communication between the parents and the school district. That's not necessarily related to the IEP, but just making sure that there are open lines of communication between the parties. The next complaint and dispute resolution processes are informal complaints. It's the policy of the Department of Ed to encourage prompt and effective resolution of any complaint in the least adversarial manner possible. The implementation of the ERP, the early resolution process, by each school district draws on that traditional model of just working cooperatively in the educational interest of your child to achieve shared goals goals that you share with the school, of meeting the educational needs of students with disabilities. Formal complaints or procedures developed under the supervisory jurisdiction of the LDOE to address allegations that the school is violating a requirement of the federal law, IDEA. And a parent, an adult student, an individual, or an organization can file a signed written complaint with the Louisiana Department of Education. The due process hearing is the most formal of all the complaint and dispute resolution processes. And this process is more like a court proceeding in which evidence is presented to an administrative law judge or an independent hearing officer to resolve a dispute between the parents and the school regarding your child. And only you, your attorney, or the school district can request a due process hearing regarding a student with a disability. Using the complaint and dispute resolution process really should always be your last resort after you've tried to resolve your issues in other ways. We encourage families to contact your local Families Helping Families Center for assistance in resolving your school issues. And to learn more about specific details about the dispute resolution options, you can join us for one of our upcoming trainings on dispute resolution options. And that training is called When Parents and Schools Disagree. Stay put can be used when you disagree with a proposed change to your child's IEP services or placement and you file a due process complaint. The stay put protection keeps your child's current IEP in place while you and the school district work on a solution. This provision allows you to dispute a change without the change taking effect, and it includes all IEP services, including related services. When you use your stay put right, your child's services continue as they are without any changes. There are some things to know, though, about stay put. You can only invoke stay put before a change occurs, okay? The prior written notice we spoke about before has to be sent to you notifying you before the proposed change, and that's when you need to make a decision. And if you file due process, go ahead and do that if that's what you decide to do. There is an exception to stay put, though. It does not apply if your child had a weapon or illegal drugs at school or at a school function, or if they inflicted bodily harm on another person at school or at a school function. So that negates the stay put right. This slide includes a list of resources to help you better understand parent rights in special education. You can email our center, and it'll be on a slide in a minute, but you can email us at info@fhfofgno.org or call us at 504-888-9111, and we'll be happy to send you the slide deck and other handouts and resources so that you'll have the links and the resources that are presented here. And here's some additional resources from some of the specific areas of IDEA. There are some additional resources that will be emailed with the slide deck upon your request. And if you need any additional support on special education or your rights as a parent, you can contact us at the toll-free number at the top. Or if you're in the greater New Orleans area, you can call us locally. And again, that's 504-888-9111. Or you can email us at info@fhfofgno.org. We provide lots of great information on our social media channels, so check us out on Facebook, Twitter, and Instagram. We also have a YouTube channel. Be sure to follow us, share our posts, retweet us. Love Disability Talk is our private Facebook group for individuals to share and provide support to each other. And again, that is a private group. Our website is also a source of great information. It's constantly being updated. We have a lot of resources on there that have been very beneficial to families already. Also, you can be added to our newsletter list and find other great resources at our website, fhfofgno.org. And again, if you want a copy of this PowerPoint slide deck, email us or call our office, and I'll be happy to email it to you. Thank you again for choosing to watch this training. By learning about your rights as a parent of a child receiving special education services, you've taken a good step toward becoming an empowered advocate for your child.